this is something that I've been thinking about for a very long time, and I've been compelled to change my mind about this a number of times. So I don't know if this overly ambitious, but if you think that the task of the board of directors is to maximize shareholder wealth, I'm going to try to make you change your minds today. So let's see how that goes. So I'm going to offer a point of view. I'm going to be intentionally provocative, but of course, whenever I say something, I mean it, and I will not say anything unfounded. I think there are many misunderstandings, myths, dogmas about shareholders. So let me try to unpack those a little bit. So what you see on the front slide here is a picture of the annual shareholders meeting of Siemens in 2012. 9,000 people showed up, though, so this is in the Olympiahalle in Munich. So 9,000 people showed up, another 50,000 gave proxies to use their voting rights. My question today is very simple. What do these people want? And how do we know? So that's deceptively simple question. So let me unpack this layer by layer, but I'll start by briefly introducing myself and my co-authors. So Joe Mahoney, who is a good friend and co-author of mine. Joe is an organization economist at University of Illinois. Leon Anajar is a legal scholar here at IE, and Joe and Leon and I are working on a paper in which we look at the shareholder. Okay, of course, everything I say today is on me. So if I make mistakes, omissions, or errors, they are my fault, but I just wanted to acknowledge my co-authors here. So just a couple things. I'm two things really and maybe number one for the purposes of today. So I'm an organization economist. I'm interested in the economics of organization and the economics of firms, and not just firms, but all organizations. So I look at buyer-supplier relationships, contracts, governance, intellectual property. The second point is really important. I focus primarily on practical governance problems. I have little patience for theoretical questions that don't have a bearing on what happens at the annual shareholders meeting or in the boardroom or in the top management team. So I really want to keep a link to practice. And these days I focus mainly on executive education. So I teach organization design and governance here at IE and a number of other schools. So with seasoned executives, we think about the practical ramifications of these things. So even though I'll be talking about theory a little today, I mostly want to pay attention to the practical problems of governance. So if you say, hey, the board has to maximize shareholder wealth, then my first follow-up question is, or first question is, how do we see this in the boardroom? What kinds of conversations? I've never heard the words maximization of shareholder wealth in the boardroom myself when I have served on boards. So I want to bring that aspect to. So I'm also an industrial entrepreneur. So I'm not just an academic. I also do practical work myself. So I'll bring some of that into this as well. I'm also a statistician. So I'm an empirical scientist at heart. So ultimately, whatever we look at, we want to look at empirically. But that's enough about me. And then just for the record, who my friends are and co-authors, so Joe and Leon. Leon is a recent acquaintance of mine, and as soon as I met him, I said, Leon, we need to work on a paper. So Leon, he's not a lawyer, he's not a JD, he has a PhD in law from Hebrew University, and he's also doing a PhD in management. So one of the things that he has helped me understand are shareholder duties. Let me pause there for a second. Wait, shareholders have duties? Yes, they may have duties. They may, in fact, be imposed a fiduciary duty of loyalty and care. So I'll come back to that. You may think of the fiduciary duty as being something that the board has, but sometimes, yes, it could also be the shareholder. We'll come back to that later. Now, most of the things that I'm saying are not my own ideas. I'm mostly channeling my own intellectual superhero, so let me just make it very clear. So I'm an organization economist. I've been influenced by Michael Jensen, Eugene Fama, Oliver Williamson, and others. But as of late, I've also been influenced by legal scholars. And Lynn Stout is probably, in that regard, one of my intellectual superheroes. She was a professor of corporate and business law at Cornell. And she's written a number of really interesting articles and also a book, 2012 book on the shareholder myth. And let me just share you a quote from her. I think this nicely encapsulates what I want to talk about today. And then there's also a YouTube video. And this is actually a quote from the YouTube video, but this is also in her 2012 book. And this brings me to the paradox, the shareholder paradox. We simultaneously seem to assume that we know everything there is to know about the shareholder. We know what they want. We know that they want just one thing and nothing else. And actually, Lynn Stout, I think her tongue was only half planted in her cheek when she said, in our theories, we effectively assume that the shareholder is a functional psychopath, in that the shareholder wants just one thing, doesn't care about anything else, and is prepared to do anything to get that one thing. And the first question, obvious question is, well, how do we know that? Does the law say that they have to, that shareholder value has to be maximized? Well, if you think so, why don't you look at the corporate law of your home country? If you find the word maximize in any form in the letter of the law, send me an email, because I've never seen the word maximize in any shape or form in corporate law. So, and Lynn Stout makes this point as well. And I have another challenge for you. If you don't find it in the law, find me a company that has written maximization of shareholder wealth in any form into its bylaws or articles of incorporation or the shareholders agreement. So it's a bit of a mystery where this notion of maximization comes from. I think I know where it comes from, and I'm going to get to it in a second. But this idea that, like Dr. Stout says, that we assume that all shareholders are the same, and that all that they care about is what's happening to the company's stock price. And actually, the only thing they care about is what's happening to the stock price tomorrow. And she says, under this theory, and when I was watching this, I said, I wonder what theory Dr. Stout is talking about. And to be honest, I'm not sure what theory she's referring to, or if she's referring to theory in the more general sense as a way of thinking, but not theory in terms of, transaction cost, economics, agency theory. So let's think about this a little more. Well, here's Milton Friedman. Most people have an opinion on Milton Friedman, and most people have never read anything Milton Friedman wrote. So Friedman was a professor of essentially macroeconomics. So he looked at monetary policy, taxation, regulation. He never did research on corporations. He never developed the theory of the firm. But for one reason or another, he became the poster boy of maximization of shareholder wealth. And the reason, this is, my interpretation. I think the reason was that in 1970, he wrote an article in the New York Times magazine entitled "The Social Responsibility of Business is to Increase Its Profits." However, he did not use the word maximize in that. If you find the word maximize in that New York Times article, point that out to me, because I can't find it. In his 1960 book, Capitalism and Freedom, he used the word once. 300, 400 pages. He used it once, and he paid a very heavy price for that. If you're interested in looking more into Friedman, I really recommend this article by James and Brasek in 2000, Business Ethics Quarterly. They wrote about an article called Smith-Friedman and the Self-Interest in Ethical Society. It clarifies many of the myths about Friedman. If you think that Friedman thought that externalities can be imposed to outsiders, couldn't be farther from the truth. He explicitly condemned coercion of all kinds. And polluting the waters is coercion. In some sense, you are coercing that, let's say, the citizens of a town to exchange their good water for bad water. That's coercion. And Friedman's definition of freedom was absence of coercion. So I've seen many texts in which authors claim that Friedman thought that imposing externalities on others was fine. No, he said just the opposite. And in fact, there's a bit of a sad footnote in this 2000 article because these authors actually reached out to Friedman. He was still alive. And he responded that he was very unhappy about some of the interpretations attached to his work. And this ought to give us pause. And I might remark that the same thing kind of happened to Oliver Williamson back in the 1990s in the academic management research community. I don't know if you read the article by Ghoshal and Moran, who essentially suggested that transaction cost economics is analogous to, have you heard the joke of the two hikers running away from the tiger? And the other says, so I only have to outrun you. So this macabre joke, disgusting joke, was suggested to be analogous to transaction cost economics and agency theory. For the record, the publication of that article, in my view, is the biggest embarrassment of the Academy of Management. I know this is going to be on YouTube, so I'm saying this out loud, but I was deeply disturbed. I was a doctoral student at the time, and I was deeply disturbed by what seemed like a willful misrepresentation of what transaction cost economics really suggested. Okay, so there are these distortions, and I really want to plant these flags for you. If you think that Milton Friedman was of the opinion that externalities can be imposed, then please go back and read what he actually wrote. Okay, so as I'm trying to, what am I trying to do here? I'm trying to map the intellectual foundation, if any, of this idea that the limited liability company exists, or that its objective or its purpose is to maximize the return to its shareholders. Lynn Stout called this a myth. I would not use the word myth, because myth is something that doesn't exist. But I think that it is patently clear that this notion of maximizing shareholder wealth, it exists. So I'm trying to think of a better word, and I'm trying to think, is it dogma? Is it an assumption? Is it a declaration? I don't know. Maybe instead of trying to think of a proper label, let me walk through a problematization of this, and let's see where this goes. Okay, so if you've heard that shareholders own the corporation, any lawyer is going to stop you right there and say, no, a corporation is an independent legal entity. That's the whole point, owned by nobody. And if you think this is just semantics and play on words, it's not. The fact that a limited liability company is an entity unto itself, owned by nobody, has actually both legal ramifications, and I think it also has managerial and governance ramifications. Okay, so where does this idea that shareholders own the company, where might it originate? Well, it might, and this is partly guesswork, but we know that the shareholders appoint the board. They can fire the board. So in some sense, we might think of the board acting on behalf of shareholders. And you might say, well, doesn't this then make the board an agent of the shareholder? And this is a fairly common way of thinking about it, that the board is in fact an agent of the shareholder. But does the power to nominate and the power to appoint imply principal agency? I don't know. Who appoints the Attorney General in the US? The president. Is the AG the president's agent? Mr. Trump had some trouble understanding that the AG is not his personal attorney. So the point of this analogy is to point out that the power to nominate, the power to appoint, the power to fire does not necessarily create a principal agent relationship. Yes, the board is formally responsible to the shareholders. But again, does this mean that they are an agent? Well, here's a question I'd like everyone, if you're a student of governance, to answer inside your head or write in the chat box. Can shareholders tell the board what to do? And if the shareholders tell the board what to do, should the board be compelled to follow instructions that are given to them? Well, if you said yes, the board has to follow instructions, I would say that's incorrect. The board does not take advice. This is what independence of the board means to me. To be truly independent, the board makes decisions independently. Yes, it can listen to shareholders. So if I serve on the board, especially as chairperson, and I see that an influential shareholder is calling, I often am compelled to pick up the phone and see what they have to say. But the moment they start giving me instructions, my response is time out. Let us just acknowledge that this is not a privileged conversation. Anything you tell me, I may pass on to the rest of the board and to all the shareholders. So just make sure that you understand that what you're about to tell me is not privileged. And that may actually be the end of the conversation. Sometimes I hear advice and I listen, but I know that if I took the advice of a shareholder and followed it, I would effectively be in breach of my fiduciary duty of loyalty and care. The recipient of which is the corporation, not the shareholder, not any individual shareholder, not all the shareholders, but the corporation. Again, here is a challenge or homework. Look at LLC law in your home country or home state, and look at whose best interest the letter of the law mentions. Does it mention the best interest of shareholders or the best interest of the corporation? In my home, well, my home country is Spain, but my country of birth is Finland, and I've served on boards in Finland, so I know what the LLC law in Finland says. It mentions the interest of the corporation. Delaware Code, which is a relevant piece of legislation, mentions, interestingly enough, the interest of all those materially affected. I like that. The interest of all those materially affected, because that invites us to think about who are all those constituencies who are materially affected. Shareholders, definitely, but also many employee groups may be materially affected. And I'm kind of channeling transaction cost economics here. Imagine that you work in the R&D function of HP, and you work on some of HP's key patents in printing. Well, you are in all likelihood committing your time and your effort and your skills and your learning into something HP specific. So you're essentially placing a wager, if you will, on the future of HP. Well, how is this different from the wagers that shareholders make? The currency is different, but you are committing to the organization in the sense that you're betting on some economic outcome in the future. So are you then materially affected? I would say that you are. You know, think of in terms of switching costs. Suppose that HP lets you go and you need to find new employment. How fast will you find it? What is the adjustment cost? And will you be able to find employment at the same level of pay? So there is this, what transaction cost economics calls commitments to specificity. So you're not only specialized, but you're committing yourself to something organization specific. Of course, the academic world is almost the opposite. If I think of, have I, in my 10 years at IE University in Madrid, have I committed to anything, any skills that tie me specifically to IE? And the answer is no. And again, I think this is the whole point. Mobility of faculty is kind of one of the nice things that we have, is that professors can move from one university to another. So we don't commit to the kinds of specificity that an R&D expert at HP would. Again, so when the Delaware Code mentions those materially affected, that could involve employees as well. Okay, so a little bit of semantics here. So when we say shareholder, we usually don't make distinctions. I'm going to make a couple important distinctions, because this idea that all shareholders are the same. Well, if you have multiple classes of shares, preferred versus common, they're not the same thing. Or if you think of majority versus minority shareholders, do they want the same thing? Well, of course, this is an empirical question, but I might note that corporate law, if you look at corporate law in your home state or your home country, I'll bet next month's rent that minority shareholders are mentioned. In Finnish LLC law, I think the minority shareholder is mentioned over 20 times, and mostly in conjunction with what the rights of minority shareholders are. Well, wait, if shareholders want the same thing, why do minority shareholders require a protection from law? Well, I think the sentiment is that sometimes minority shareholders don't want the same things as majority shareholders, and that's why we need to legislate this. Okay. And then when we say maximize, we don't really mean that. So Michael Jensen has made this point on several occasions, that when we say maximize shareholder wealth, we don't really mean that. We mean increase. And if we say increase shareholder value, then I'm more inclined to say, okay, that sounds better. But maximize, I mean, I'm assuming I'm talking to mostly academics here. We want to be rigorous with the use of terminology. Maximum means the tallest point or the lowest valley. That's what maximization means. If we don't mean that, then let's not use the word. Then let's use increase or good enough or whatever, but let's not confound issues by using words in meanings. And I have similar problems with other terminology that we use in management research. We adopt words. Let me just briefly digress to my work on reasoning. We talk about induction when we don't really mean induction. We say deduction when we don't really mean deduction. So we use them as labels for reasoning processes that are not quite what they are in the philosophy of science literature. And this can lead to confusion. When somebody says theory emerges inductively from data, I really have no idea what they mean by that, what they mean by induction in that context. Okay. And then when we speak of value, whether it's shareholder value of any value, what is it that we really mean? Let's say shareholder value. What do we mean? Book value of equity? Market value of equity? Share price, Tobin skew, market value of the firm? It's interesting how when we speak of shareholder value or value, we typically don't say exactly what we mean by that, what value we're looking at. And William Lazonick, who is an economist who has written about this, has made this point very eloquently. So has Michael Jensen. Michael Jensen actually focused more on firm value than he did on shareholder value. So instead of just focusing on equity and the value of equity, he said, why don't we look at the firm? Let's not ignore debt. Let's not ignore all the claims, all the financial claims that may or may not be linked to equity. Some of them are linked to equity directly, like shares, others indirectly, such as convertible debt. And then finally, when we say long-term, what do we mean by long-term? How long is long? And again, the specifics are lacking. So given this, how can we possibly have an informed discussion on maximization of shareholder value? I haven't had one so far. Maybe one day I will, but we really need to get the terminology right. We need to specify what we mean when we say maximize. We need to be clear about what we mean by value. And before we lump all the shareholders into one category, before even asking, do they want the same thing or not? Well, we know that in point of fact, they don't want the same thing. And we have multiple cases, even litigation, showing that shareholders don't want the same thing. There's a really interesting case, if you're interested. Desktop translation software company called Trados, Trados, was acquired by a large incumbent in, I want to say 2013. Well, the year isn't relevant. Was purchased by a large incumbent. In the deal, that was about, I hope I get these numbers approximately right, 70 million, I think it was the purchase price. Preferred shareholders pocketed most of that. Managers of Trados pocketed the rest. Common shareholders got nothing, zero. And common shareholders were, understandably enough, not happy. One of them decided to litigate the board for getting nothing. And the Chancery Court of Delaware, in its judgment, the judge said that the common shareholders receiving nothing was, the judge's words, entirely fair. Okay, so here we have a real life situation where preferred shareholders pocket what 60 million, common shareholders pocket nothing, and the judge says this is entirely fair. Well, if we really want to understand what happens out there in real organizations, this is the kind of stuff that we need to understand. Is what is the reasoning here? Why did the common shareholders get nothing? What were they interested in? What was the plaintiff's claim? Why did the judge not find it compelling? And so this is the kind of stuff that we have to dig deeper into if we want to understand what's going on. But I'll let you Google Trados if this piqued your interest. You'll find all kinds of interesting stuff on Trados online. Okay. And I know that Ibrad is scanning the chat box, so if there's anything there, I instructed him that if there's anything in the chat box that he would like me to comment on, he can interrupt me. But when we're done with my talk here, I'm happy to entertain any questions, any comments that you might have. I want to make sure that there is no confusion here. Okay. I'm also a student of analogy, so let me take a soup kitchen analogy, and let's see if we can make some headway here. Shareholders, if we don't describe them as owners of the firm, and I don't, although I tell my executive students, I don't care if you call shareholders the owners of the firm, as long as you keep in mind what that ownership means. And what does ownership of shares means? In what sense are shareholders owners? Well, they are entitled to a number of rights. They are entitled to the rights to make some decisions, such as appoint the board, and they are entitled to the residual income of the firm. Okay, so if there's something left over at the end of the year, that in some sense belongs to the shareholders, although a lot of the time shareholders don't really get to decide whether they get any of that. But this idea of shareholders as residual claimants, I think that's a good starting point. So let me move to the soup kitchen analogy. So in the soup kitchen analogy, the shareholder is the last person in line. In front of the last person are all those constituencies who are entitled to receive fixed payments from the organization. So invoices need to be paid, taxes need to be paid, salaries need to be paid, and of course, depreciation is a real cost, so that needs to be paid. And then if there's something left over, then that is for the residual claimant. Okay, so then it can be either reinvested or it can be given out as dividends, but that's the stuff, the surplus, the net income is what belongs to the shareholders. So let's see if I can build on this analogy to kind of motivate what Leon, Joe, and I are looking at. So when all the contractual obligations are met, shareholders are the residual claimant who are entitled, sort of, a qualifier, to what is left over. And this is an argument that I've seen, is that if you take care of the needs of those last in line, then by implication, you will have taken care of everyone's needs. Okay? And I don't know, this might be, for the cooks who cook the food and those who serve the food in the soup kitchens, making sure that the last person in line receives food, that seems like a reasonable premise. Okay? But let's see if this analogy is actually valid. Well, here's the challenge. In the soup kitchen example, those who are last in line, they do not get to appoint those who exercise oversight over those who cook and serve the food, nor do they have the power to reprimand the cooks and the servers if they misbehave. So if we want to understand this in the context of corporations, we need to theorize the residual claimant more rigorously than we have. We need to understand, and some of these are theoretical questions, but some of them are empirical, but I think we might start with a theoretical question of who the shareholders are. What objectives do they have? What duties do they have? How do they choose to use their actually very limited power to appoint, monitor, and reprimand, and whether these powers actually have practical significance? Okay, so imagine a massive corporation like Siemens with tens of thousands, if not hundreds of thousands of shareholders and just incredibly fragmented ownership. The ability of shareholders to monitor, to reprimand, to replace the board is highly limited. We may even come to a conclusion that the board effectively appoints itself. Okay, so, and this is actually one of the things we then want to look at when we theorize the shareholder is, are there any influential block holders? Or what is the degree of fragmentation in ownership? Okay, so again, wait, shareholders have duties? What are they? And this is actually something I did not know until very recently when Leon Anijar, the legal scholar, he said, yeah, if you are a controlling shareholder, you may owe a fiduciary duty to the corporation. This means, among other things, that when you vote on issues, the annual shareholder meeting, you may not be able to vote any way you want. Instead, you may have to consider the best interest of not just you, not just the shareholders, but the entire corporation. And again, this varies from jurisdiction to jurisdiction. I have talked to experts in Finland, again, my country of birth, and they say they do not see how the Finnish LLC law or legal practice would impose a fiduciary duty on shareholders. But in countries like Israel, where Leon is from, he says this is actually the case. So this is highly context dependent. But again, first of all, we need to theorize this, and then we need to look at this empirical. And Cohen 91 is kind of the classic reference on the fiduciary duty of the shareholders. So what do we need to do to unpack this? Well, first, let's create a nuanced typology of shareholders to understand shareholder heterogeneity. So let's look at all those constituencies whose interests are tied to shareholders' equity, and then ask what rights and responsibilities do they have? They certainly have rights, but we also need to map out the responsibilities. And as the second step, and again, I'm channeling transaction cost economics here, when we do a stakeholder analysis using transaction cost economics, we might take, let's say, employees, for instance, or suppliers. Let's say HP suppliers. HP has about 1,000 suppliers, and you're probably not surprised to find out that some of these suppliers are absolutely essential, strategic, while others are not. A good litmus test is if you pick up the 10K form, just look at which suppliers are mentioned by name. If they're mentioned by name, then their identity matters. So if you read HP's annual report, the 10K form, you will find Microsoft, AMD, and Intel, among others. So you have these kind of strategic suppliers with very strong bilateral dependency. And then you have scores of arm's length suppliers for nuts and bolts kinds of things where there is no stakeholder relationship of any kind. Well, our invitation is to extend the same kind of analysis to shareholders or claims to equity and say, okay, who are the different kinds? So first of all, let's look at whether there are different classes of shareholders, preferred versus common. Let's look at, if there's only one class, let's look at the fragmentation. Let's look at if there are block holders, are there majority shareholders? Does someone own 50% plus one share? Or are there otherwise influential shareholders or blocks of shareholders who own more than 50%? And then let's look at minority shareholders. And then let's look at all indirect claims to equity as well, convertible bonds, and so on, anything that ultimately links to equity. And then let's explore, let's theorize the governance ramifications, just like we would in buyer-supplier relationships. Okay, so I'd love to see the contracts that HP has with Intel. I'd love to see what kinds of safeguards are in place. What kinds of clauses are there for unilateral termination of the contract and so on? And what other extra contractual measures, governance measures are in place to ensure that that relationship is on a solid footing? Because if Intel lost HP as its customer and HP lost Intel as its supplier, the implications for both might be devastating. But then there are other relationships that Intel has with his, that HP has with its suppliers that really don't require any governance. They're just arm's length transactions, no long-term commitments, no commitments to specificity. Those do not require the same kind of attention. So same thing with shareholders. Let's look at the relationships that they have. And let's make sure that we fully understand the relationship that the shareholder has with the corporation. I know that some scholars describe the relationship between the shareholder and the corporation as contractual. I tend not to. So Lynn Stout, for instance, she says when you buy a share in a corporation, that constitutes a contract. But to me, it's a very different contract than, let's say, an employment contract or buyer-supplier contract. Or if we think of what kind of a relationship does the board have with the corporation, is that a contractual relationship? I guess if you broaden the definition of contract sufficiently, then anything is a contractual relationship. But I would make a distinction between a fiduciary relationship and a contractual relationship, even though the fiduciary relationship could, I guess, be labeled contractual if we stretch the definition enough. Okay, so let me show you how are we doing on time. I think we're fine. I don't have a whole lot here left. I have a couple more things, and then let's see. I see there's a lot of stuff in the chat, so I'm eager to see what's there. So what are Leon, Joe, and I trying to do? So this is in very early stages right now, but I wanted to share some of the ideas with you anyway. So we thought, let's create a 2x3 matrix. In one of the dimensions, we'll just take Hirschman, voice exit, entry, voice exit, because we thought when we look at the shareholder, we really need to understand kind of their state of mind as they're contemplating becoming shareholders, when they are actually shareholders, and then when they're contemplating selling their shares for one reason or another. And then in the other dimension, we want to distinguish between what we call the investor view and the corporate view. And the investor view focuses on shareholders as investors who seek a return on their investment. So we make an assumption, and I hope this is a reasonable assumption, that you become a shareholder because you seek returns on investment. If you don't seek return, then you're effectively a donor. And there are organizations that are organized as ones where donors provide the financing. But if you buy shares in a limited liability company, I think it's reasonable to assume that you seek a return. Not maximal return, but return that's good enough. I'm sure many of you are shareholders, and you're looking at your portfolio and you're looking at whether you're happy or not. I think you're not asking the question, is my value being maximized? I mean, how would you know? But you probably ask, am I doing okay? Should I do something about this? Should I call my broker? Should I think about investing in treasury bills instead of stocks? Should I go into raw materials? So these are probably the questions you ask, but I don't think you ask the question, is my wealth being maximized here? Again, how would we even know? Then the corporate view looks at shareholders from the point of view of the corporation. So shareholders are stakeholders with rights to residual control and to residual income. And then what we want to do is we need to understand 6 different, depending on what you're interested in. If you're interested in examining what shareholders want, how about focusing on 1, 2, and 3? If you want to understand how boards function and how the board orients itself toward shareholders, then you would probably focus on maybe 4 and 5. And for the non-expert, the notion of alienability of residual claims simply means, are there any restrictions on buying and selling shares? If you buy shares in publicly traded companies, you can buy and sell as much as you want, as long as you find a buyer and a seller, there's a market price. But if you are a co-founder in a startup, the chances are that the shareholders agreement puts limits on whom you can sell your shares. It could be that you're first required to offer your shares to the other founders, or that the company may purchase your shares at book value if you want to get rid of them. So you're not allowed just to sell to the person on the street and say, hey, you want to become a shareholder in a startup. No. So the alienability of residual claims is often in startups restricted, whereas in publicly traded companies, it's actually almost antithetic. You want to make sure that there are no restrictions there. So depending on what you are interested in, hopefully when we really flesh this out in the article, this may help, first of all, focus our attention, then ask the questions, and then think of, okay, how do I tackle this theoretically and empirically? So ultimately, this would be something that we want to propose for empirical research, but for now, we're working on the theory part of this. Okay, so let me bring one anecdote. This is actually from the book that Joe and I wrote. So the question of board structure, board composition. Who should have a seat on the LLC board? Should shareholders have a representative? I mean, we know that shareholders have the power to appoint, but should they appoint their own agents? Should they appoint someone who looks after their wealth, or even exclusively after their wealth? Or, as is now more common, is to say representatives of broader stakeholders. Well, Joe and I noted that we're amazed at how casually we forget the fact that the director owes the fiduciary duty of loyalty and care to the corporation, not to the person or the entity who appointed them, but to the corporate. This is not good governance. This is the law. This is what the law says. Okay. So the only beneficiary of the board member's fiduciary duty is the organization. So if I am a shareholder and I appoint my agent to look after my interest on the board of directors, I am breaking the law, at least the spirit of the law. Of course, will someone litigate me for this? Probably not, but I'm making this point as a point of law and of practice. To understand that the fiduciary duty is not to, and I think this is probably why many companies choose not to have labor representatives on the board. I know that GM, for instance, used to have a union rep on the board. I don't think they do anymore. I think that I don't know what the actual reasons, but one plausible reason is that the conflicts of interest are so profound. Suppose that GM is contemplating the closure of a plant in small town Michigan, and there's a union rep on the board. How is the union rep going to vote? I mean, the conflict of interest and the divided loyalties are just so profound that it's hard to see how a union representative would be an independent fiduciary of the corporation. But I might say the same thing about shareholders, that shareholders also, they have a vested interest. So this really is a dilemma. This really is a dilemma. So is there any way out of this? Well, Neste is a Finnish oil company. And I tried to find the best picture I could to depict what Finland is like. So I found a picture of a guy putting gasoline in his snowmobile in Lapland. So this is the best I can do. Okay, joking aside, Neste, here's a couple things about Neste's board of directors. And actually, if you look at other Finnish companies, you'll see similar characteristics. All board members are independent of both the company and its largest shareholders. And only 2 of the 8 board members have a non-trivial equity stake in the company. 4 own no shares at all. And there is no equity-based pay. Board compensation is limited to fairly modest, I would say, annual retainers between 30 and 70,000. I know that, if you look at the US and if you just look at the New York Stock Exchange governance guidelines, they actually endorse equity-based pay for directors. But if directors are not just top management team, but if directors are compensated by equity, then how can we argue that they're independent? Because now their interests are tied to the price of equity. So I think that Neste and many other companies have realized something really crucial about what independence of the board means, that there are no agents of the stakeholders or the shareholders on the board. The board is truly a fiduciary of the corporation. Of course, it has to take shareholders' interest into account, but it does it without having a vested interest itself. I'm a big fan of this kind of independence. Then, of course, we also want the board to be not just independent, but we want them to have expertise and diversity and competence and whatnot. But the baseline, I really like the idea of completely independent in its judgment, not just formally independent in the tick the boxes sense, but genuinely independent. And whenever board membership is a significant source of revenue for someone, I don't see how you could argue that that board member is independent. Warren Buffett has said this on many occasions. I don't understand how someone whose income depends on serving on boards can be independent. Because what are you going to do if I get 250 grand a year by serving on the board of a bank? What are the odds that I'm actually going to pay more attention to those who have the power to fire me, which is the shareholders? I think it's just human condition. Who's going to say, you know what, I have so much integrity, I don't care about the $250,000 that you're paying me. I'm going to do this. I know that it may not be in your best interest, but I'll do it anyway. Okay. Okay, I just spotted Robert wrote about co-determination. That's perfect. Robert, would you like to maybe elaborate a little bit, and then I'll respond?
My main point has to do with systems such as Germany and Netherlands,
yes, and
where
Finland.
you have different constituencies. Now, if a board member comes from the labor side, or in Germany from one of the states representing the interests of Volkswagen workers in Hanover, how is that different, or how is that possible? That person is concerned about the company as a whole, and do they not have to weigh these things?
I mean, that's a very good question. So co-determination is also in my country, birth in Finland, it's written into law. There is the co-determination law. So, for instance, if a company is closing down a plant, it needs to understand that it can't make the closure decision just purely as an executive decision. There are co-determination laws that compel the company to take into account the consequences to employees. I don't know if US states have co-determination laws, but of course you can also tackle this contractually. GM has a general agreement with United Auto Workers, for instance. So GM cannot just decide, oh, we're going to close down a plant. United Auto Workers is going to have a seat on the table, and they have a voice in the decision. I think GM made this very clear to President Trump a couple of years ago when they said that, hey, this is something that GM and UAW will decide. But here's and I think this is where co-determination becomes problematic. If we think that employees have representation on the board, then I find that problematic, because the only entity that the board represents is the corporation. So I understand the sentiment of stakeholder participation on boards, but what happens to the board? Let's say the board has 12 members and it has representatives from shareholders, from employees. I've worked with companies that had actually customers, very powerful, large customers. They had a seat on the board. And then let's say they have bankers on the board. How does a board like this make decisions if everyone is representing an agent and is an agent of a principal, and these principals have only partially overlapping, if not conflicting, interests? How does a board like that make decisions? So I think that this idea of representation, whether shareholder or stakeholder on board, I think it becomes problematic when we try to think of what is it that the board is supposed to do? How do they make decisions? So whether we talk about employee representation or shareholder representation or any representation, we really need to be careful. Here's Larker and Tayan, they wrote a book on governance, and they made a point about bankers on boards. Would we be surprised to find that when you add bankers to the board of directors, the company starts leaning more toward debt financing? Probably not all that surprising. Well, then we might ask, why does this happen? Are bankers pushing debt financing? If they are breaking the law. They are in breach of the fiduciary duty of loyalty and care, which is to the corporation and not to the bank that maybe had the power to appoint them. But of course, like Larker and Tayan said, these kinds of breaches are very, very difficult to notice. But still, I have been many times in the boardroom when I have asked myself, I wonder whose agenda that person is promoting right now, because it doesn't seem like it's the corporations. Is it someone who appointed them? There is a hidden agenda here of some kind when the only agenda that should be on the table is the interest of the corporation. Okay, I don't know if that answered the question, but of course, why does Germany have co-determination? I think if you look at I think someone mentioned this in the chat. Of course, there are historical, political undercurrents here. If you look at the history of Finland, for instance, Finland has always depended heavily on industry, manufacturing industries, and industries that depend on, skilled employees, both highly skilled and low skilled employees. So employees have always been central in that sense. So I don't find it surprising that in Finland we have co-determination laws as well. This is partly shooting from the hip, but just making the point that there is a historical explanation here probably as well. Prem, I see you have your hand up. Go ahead.
Thanks for the interesting presentation. I agree with some of your ideas regarding Friedman that didn't say anything, but people quote him. Mm-hmm. But there were a few questions like regarding the law. So you say it is not written that the goal of the firm is to increase shareholders' value. But
okay. Let me stop you right there, because words are really important. The word maximization is what I take issue with, but the idea, and this is actually in Finnish LLC law, that this is point about the form. The point about the LLC form is that providers of financing are investors. I mean, that's the basic premise in an LLC, that those who provide financing are seeking a return. So this is actually written in the law in Finland as well, that an LLC must seek profit. Okay, it doesn't say how much. So effectively, it simply says that an LLC is a for-profit organization. That's the extent of the law. Okay, I just wanted to apologize for stopping you there, but words matter greatly here. So
I
go
agree.
ahead.
They are very important for conversation as well. And thanks for this clarification. So my concern is that there are many laws which are, let's say, pro-public, are in the interest of society. For instance, we have laws for child labor. We have laws for bonded labor, and companies do violate those laws. So, and then we come to the what is not written in the company's documents, but what we are teaching. So now you take the book taught to any business school. It could be Introduction to Business. That is the first course that I was taught when I did my bachelor, or it could be Principles of Management or something else. The name could be different. What are we taught? We are taught that the goal of the firm is to maximize shareholders' value.
I revisited
those books I revisited those books because I do little work on these things,
Mhm.
and this is what is interpreted. So maybe legally it is not written, and you have rightfully explained the case of
Mhm.
Finland or Sweden, Nordic countries. Freeman and Strand has wrote about that in their article in Journal of Business Ethics, explaining that it
Mhm.
has been for centuries that the firms were like this. But the unwritten laws, for instance, now while you were presenting, I was a bit, interested, and I went through a book that is recently published on the history of corporations. And this author says that corporations were born in Rome to protect Rome when Rome were losing the war.
Sure.
So
Sure.
now,
Okay.
even in the law, in Roman law, the purpose of the firm is not to increase, or let's say, was to do the common good for Roman society. This is why corporations were created at the first time.
Sure.
So they
Sure.
were not created to increase profits, but they were created to protect Rome, common
Okay.
society, common area of the Rome. But the thing is, it is not what is written, it is how it is practiced.
I fully agree. I
Practice
fully
and
agree.
what is
Okay.
practiced at large. So
Okay.
Britain does not have a written rules. It does
Okay.
not have a
Okay.
document like that. But what British did in India as a company, East India Company, is in front of you. And now what other companies are doing is what the problem is. And how do
Okay.
you look
Okay.
at it?
Okay, so first of all, you make a couple very important points. One is, yes, this is how we teach it. I don't teach it that way, but I know many who do. So when executive students come to my class, they're first a little confused about this, but then we start unpacking this. So yes, I know, and I've heard this in the classrooms, in the hallways, yeah, maximize, 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 okay? But one of the problems is that we often forget what you just said, that there are other laws as well. Okay, so the LLC law is a law about the legal form of the corporation. Okay, but firms are also employers. And if you're an employer, then again, there are, in my native country, Finland, there are about 15 laws, employment laws, for instance, that stipulate all kinds of things that you have to follow. So the firm is not just an LLC, it's also an employer, it's also a customer and a supplier, which means that a whole host of contract laws apply. So when somebody says that the purpose of the firm is to make a profit, no, that's only a point made about the LLC form. But then when you look at all the other things that the firm is, you realize that this whole notion of maximizing shareholder value, it just becomes painfully irrelevant and unoperational. And that's probably why I've never heard the words maximization of shareholder value spoken in the boardroom. We speak about something else. We speak about creating revenue. We speak about how do we raise more equity and, things like that. But we don't say, okay, how do we maximize? Let's put our hands in the dirt and start maximizing shareholder value. It's just a painfully inoperational metric. It comes from, if you want to look at how they derived maximization of shareholder value, the argument was that under highly restrictive conditions, all exchange is voluntary, no monopolies, no externalities, everyone buys and sells whatever they have to offer at market prices, then you can show, just through marginal calculus, that maximizing shareholder value maximizes social welfare. Okay, that's Michael Jensen. He did this 20 years ago. But let's take that to the real world. There are externalities, there are monopolies, resources do not have unambiguous market prices, and the idealization just collapses like a house of cards. Okay, so those who speak about maximization are speaking about a firm that doesn't really exist. That's my interpretation. They're not speaking about real firms. They're speaking about the idealized firm that doesn't exist in any setting. But idealizations are always a good starting point for further analysis, but they sure as heck shouldn't become the end point of analysis. So we should take what Friedman said, and what Jensen said, and then start working out the ramifications as we start relaxing those assumptions, see what happens. Then we can start to understand real firms. Akwasi, you have your hand up?
Yes, thank you. I wanted from the beginning of the presentation to get a better understanding of the problem that we are trying to fix. A lot of the presentation has been around the language of maximization, and I'm completely with you about this misuse of the term. But I'm not. From the conversation that just happened now, it seems to me that one purpose could be a pedagogical one, that we don't continue to reproduce that in our students. I wasn't sure if there's other purposes or problems that we're looking to solve with this.
Okay, very good. Fair challenge. Excellent. And thank you for, and please push back, because this is a point of view. And like I said, I am intentionally provocative. I really want to get us out of the comfort zone of convenient assumptions. So let me put you in let me just briefly revisit trade-offs. Let's say that you are the chairperson of the board, and an incumbent has just made a purchase offer that looks good. It looks very good for your preferred shareholders, but it looks like a doo-doo for your common shareholders. What do you do? What do you do? So these are real situations that boards find themselves in. And if you said, well, you need to maximize shareholder wealth, well, which one, the preferred or the common? Because the two, and Michael Jensen said, you can speak of shareholder wealth only if you can show that all shareholder utility functions are monotone transformations of one another. If mine increases, everyone else's increases. But the word preferred, almost by definition, means that no. If you look at the utility functions of preferred and common stock, I don't think you're going to see monotone transformations. And we saw this then happen in the acquisition. Common shareholders pocketed nothing, preferred shareholders pocketed 60 million. And now, as then you're the board chairperson of the board or a board member, and you get a call from your lawyer and says they're going to litigate the board. Okay, so then you start asking, did I make the right decision? Should I have acted in the best interest of the common shareholders instead of the preferred? Because this was something that then had to be litigated. The plaintiff's case was the following. They said the board breached its fiduciary duty by selling the company too quickly. And because it was sold so quickly, common shareholders got nothing. The plaintiff asserted that the board should have kept building value for the firm until the common shareholders would have benefited as well. And the judge came back and said, no, this is not what boards need to be doing. So it was not, the judge said this is not a breach of fiduciary duty. So see how this case invites to think about the time frame. So the common stockholders said longer time frame. The board said short time frame. And of course, the preferred stockholders, their interests were served by the board because the preferred shareholders had handpicked the board themselves. So the board was essentially, in many ways, de facto an agent of the preferred shareholders. And this is what the outcome was. But I don't know if the board members sweated on their way to the court to see whether the judge would say that, hey, you have to consider the interest of the common shareholders as well. And I don't know how sure they were that they would prevail and they would not be found to be in breach of fiduciary duty. Okay. I don't know. It's Akwasi did that. I really want to try to build a bridge to practical decision situations. And I think the next book I want to write is kind of a book where I take the reader to these kinds of decision situations and say, what would you do? What do you think you should do? What do you think the law compels you to do? If you do this, do you think you'll be in trouble? So instead of talking about maximization and value and such in the abstract, put the reader on the hot seat and say, what would you do in this situation and why? And how would you justify your decision to those who will be materially affected, especially if they're negatively affected? And I use this as a pedagogical technique with executives. We don't talk about theory. I say, here's a scenario, tell me what you would do. Akwasi?
Yeah, so what I'm hearing, and I think it's very important, is it's kind of trying to improve the understanding of boards of their fiduciary duty and to broaden that.
Yes.
I think that by hanging it so much on the idea of maximization, it actually makes your idea, it doesn't bring across the full goal of your idea. Because according to what you're saying, all of this is going on in the boardroom without anyone ever saying maximization. So that's not the problem. I think the problem is that it's a power struggle, and the decision makers, according to you, need better guidance about how to resolve that power struggle.
Okay,
I think.
Yeah. I really don't want to. I have a very biased and small sample of boardrooms, so I don't know if in other boardrooms if this is something that's being said. But if shareholder value maximization is something that's uttered in the boardroom, I am afraid that it's uttered in an attempt to essentially trump any other claims. And Lynn Stout made this point as well, that if somebody says, but hey, the law compels us to do this. Well, if the rest of the board members are uninformed, and McKinsey does these massive board surveys every couple of years, I think, and many of the results are really cause for concern. And when I talk to very experienced board professionals, they say that the level of expertise on boards is declining. And as I'm asking, why do you think that happens? The answer is that many board members, very smart board members, are understanding how they can now be held liable for things that the board does. How many times has Tesla's board been litigated by shareholders? At least 20 times. Okay, so shareholder litigation, I think, is becoming more common. And just this idea that boards become paralyzed because they are so worried about compliance, they're so worried about liability, that the first thing they want to know is, are you going to take out a director's liability insurance on me, which ultimately may not protect you a whole lot. So I think if this is true, this is a very unfortunate development, that the professionalism of boards is going down. Smart people are less likely to join because boards are held jointly responsible. That's what the board of directors mean, that the board is held jointly responsible. So I worry that the level of expertise is going down when really it should be going up as much as possible. Just think of the biggest corporate scandals and think of what might have been causing that. It's usually bad governance. Bad governance combined with unprecedented greed or opportunism, but usually the inadequate separation of management and oversight. I think that's kind of the basic formula in so many corporate scandals, is that the board just wasn't able to control and exercise oversight over management. And this is has been the concern with Tesla for many years. The Solar City acquisition, Elon Musk's 50 billion, that's million with a B, executive a compensation package. So these are the kinds of concerns that we need to bring on the table. And if this happens and the level of professionalism and expertise on boards is going down, yeah, this does worry me quite a bit.
Mikko, I saw there were earlier a couple of hands raised by Maria and Ravi. I don't know if
Okay.
Ravi would like to ask the questions.
Yes, please go ahead.
Yeah, this is Ravi. I really like your conclusion, which is the interests of the organization should really be the matter. But your starting point, which is shareholders paradox, that was very much confusing because nobody assumes that all shareholders are the same. Really, nobody really assumes that. So that's a false foundational premise that you began. But I like your conclusion because that's what should matter really. So in fact, Ari Degoose, I wrote this in the chat, talked about the living company. And he says that the key performance indicator for any company should be longevity. How do we survive now and thrive in future time periods? And that can happen only if all stakeholder interests are met. And
fully agree. So
because it's almost like a linear programming problem formulation. You have an objective function to maximize or minimize, and subject to a lot of constraints. You have constraints coming from outside, external constraints, regulatory constraints, market limits, and also internal constraints, our own capacities within the company and so forth. So given that you have to work within all these constraints, and you kind of alluded to this in your own speech, that you have to really work within the confines of all the constraints that are imposed upon you. But at the same time, some objective function, some overall maximizing or minimizing function would be the North Star that would lead everyone towards that. That could be profits, that could be some other value criterion. And somebody in the chat talked about what is value. That person is talking about you have to define value before we can go on to any.
Sure.
But it's more like a linear programming problem formulation. You have to meet all the constraints and then maximize or minimize whatever you deem to be the objective function. That's all I have to say.
Okay. Thank you, Ravi. So a couple things. First of all, this idea of an objective function. Michael Jensen writes about it. A lot of mathematically oriented economists, financial economists talk about it. But again, how do you decide what that is? I like the idea of longevity, although I would replace it with the word viability, because longevity assumes that the organization needs to exist for a long time. Well, this may or may not be it may be an organization that's designed to live for 2 years. But when I say viable, it has to be viable in those 2 years. So it has to secure the cooperation of all the value creating constituencies, whoever they may be. So employees, suppliers, customers, providers of equity financing, debt financing. So, and this is in our book, Efficient Organization with Joe, we said that this is the objective of efficient governance, is to ensure the viability of the organization. But there's really no objective function, and certainly not an objective function that is about the performance of the organization, and even less a measure that's a bottom line measure. If anything, I would look at top line measures or measures of value added instead of measures of residual income. So that's how I approach it. I look at the viability of the organization, and then I look at the coordination of value creating efforts. Now, this question, does anyone assume that shareholders want the same thing? Anyone who says that companies should maximize shareholder value is implicitly assuming that shareholders want that one thing. And that's what Lynn Stout is referring to on this slide, that if we look at the implicit assumption in many of our theories, I don't think many smart executives or board members think about this. Dr. Stout's critique here is more aimed at the academic community than it is to the practitioner community. Most of the very experienced board members and executives I know, they know that there is no duty to maximize anything. Okay, there's even no duty to try to maximize anything. So if you fail, there is no, you can't litigate someone for bad management. You can't even litigate someone for being greedy. You can only litigate if there's a breach of contract or if they have broken the law. And as someone who has tried to litigate the board, I'm telling you, it's futile, it's expensive, and it's extremely annoying. So, because, you know, it's not just a question of what happened, it's a question of what you can show. And you have to show intent. And showing intent is really difficult. Okay. I see Loretto, you had your hand up, and then I want to give it back to Robbie as well. So Loretto, go ahead.
Well, I think Maria's before me, but I'm happy to go.
Okay, yeah,
She's been waiting for a while.
Yeah, go ahead. Yes.
So my question is, I've been a company secretary for 20 years. So what you've been saying definitely is what I've seen in boardrooms, and
Okay.
boardrooms of all various sizes and in different sectors. So it's
Okay,
really
thank
good to
you.
see. But my question, and I've had a quick look through your book, and I think you pick it up in your book. I think what you're talking about is for you know, highly regulated, very exposed organizations like listed companies. If you think of it from a proportional point of view, if you have something like a company that's an investment fund, you know, it'd be perfectly fine to have shareholder directors there that are
Sure.
kind of
Yes,
push
yes.
value. And maybe I thought it might be useful to just pick that up.
Yes. No, that's a very good point. So the book, Shameless Marketing Plug. So it's not just about established. There is an entire chapter on startup organizations. But yes, so everything should be analyzed. So if you're trying to, we just did this in my executive class on org design. I said, everyone take your own organizations and do a stakeholder analysis. Who are the most important constituencies in your specific setting? Okay. And as you might imagine, the answers are highly diverse. In some companies, employees are, you know, any organization that relies on R&D and scientific work and high education of workforce, you know, employees are going to be central. Okay. Any industrial firm that uses highly specialized assets that have to be financed through equity, you know that providers of equity financing are absolutely essential. I've been the chairperson of a company that was just like that. And let me tell you, in the boardroom, one of the most common topics was, how do we keep shareholders happy? The current shareholders, so that they will, you know, provide when we do our 5th round of financing, that we can still reach out to them. And then how do we attract new providers of equity financing? So yes, in that context, in some sense, the shareholders were the kings and the queens, in the sense that if we can't raise the equity, then any stakeholder conversation is a moot point, because we're not going to survive. Okay, so I'm not saying that shareholders aren't important. What I'm inviting you to do is not to take it as an a priori assumption that the law compels you to worship them. But if you really need to take care of the shareholders, and if you need to secure continuing equity financing, yeah, this needs to be number 1 or 2 on the board agenda every single time. So it's all about doing a comparative analysis of what is important. Although I might note that raising equity was tough. But guess what was even tougher? Convincing engineers to join the company, a high-risk startup with no guarantees of any kind, have them leave their previous employment and take a bet that this company is going to take off. Putting your money at stake is one thing, and losing on an investment, that's one thing. But taking a gamble on employment, on your career, that's quite, when was the last time you gambled in your employment contract? I mean, just a rhetorical question to ask. Robbie, let me give it back to you. We wanted to come back to the point that we discussed earlier.
Yeah, I was just reacting to when you said there's nothing to maximize. And I want to challenge that aspect of your main speech, that there's nothing to maximize.
Okay.
I was very deliberate in invoking the metaphor of the linear programming problem formulation.
Sure.
Having an objective function to maximize or minimize, to optimize subject to a system of constraints.
Okay.
There's always something to optimize. There's always, maybe what you try to optimize changes from minute to minute, from time to time, from context to context, from the systems or realms of your responsibilities that you focus on. But there's always something to optimize. That is a given. That's what I want you to really reflect upon and try to take back. I'm trying to challenge you to take back that notion that there's nothing to maximize. There's always something to optimize. For example, if you look at process maps, in every process, there is a bottleneck.
Sure.
So
Yeah.
you focus on that and you immediately try to optimize that. And even when you try to take care of the bottleneck, there's another bottleneck that reappears because you strengthen this. Somewhere else, there is a bottleneck. So I want you to really think about this whole idea that there's always something to focus on and optimize, whether to maximize or minimize. That's the only challenge I'm trying to throw at you.
If you assume a closed system, yes, then yes. But imagine a production system where the demand pattern changes from day to day. So you don't know what your demand is going to be tomorrow. You can't even put a distribution on it. So yeah, I've done 20 years of work on processes as well. But optimizing processes requires a comparatively stable environment. But if we throw in ambiguity and uncertainty into that, I think the practical significance of optimization and maximization simply becomes inoperational.
No, Mikko, I don't want to take too much time, but this requires deep reflection on your part, because it's not just internal constraints and external constraints that are imposed on the system that you look at. There are even aspirational constraints which have nothing to do with your internal and external constraints. Maybe I want my company to double in profits. That's an aspirational constraint that I'm imposing upon the system I'm looking at. Again, I don't want to prolong this discussion. There's always something to optimize. It's a never-ending thing that keeps appearing again and again from minute to minute, every second to second. That's all.
Okay. Let's agree to disagree on that. We can maybe continue this offline. But I hope that the problematization. So I'm speaking. I'm kind of trying to do several things here, and it may be a little confusing. There is this theoretical question of how do we theorize about these things, and then how do we do empirical research on these things, and then of course another question is how do we teach this in the classroom? What do we ask our students to do? What kinds of problems do we give them to chew on and try to find answers to? So there's a pedagogical question here, there is a legal question here, there's a practical question. But the first thing that we try to do with my colleagues is to think of how we could think about theoretically about the diversity of different claims to equity. And see if we can say something about this theoretically. Can we create first a typology and then work out the governance ramifications? And again, I'm channeling transaction cost economics when we're looking at how relationships should be managed, or if we're looking at governance questions and we're looking at should I consider the supplier a stakeholder or just an arm's length relationship. This is merely a rhetorical exercise until I specify the governance response that is required to secure the cooperation of that constituency. So if it's the HP Intel relationship, then the question is, what should HP and Intel do so as to secure the viability of that relationship as long as needed? So essentially, secure the viability of the relationship. And if you secure the viability of all the relationships, which I think is the basic task of governance, is that you secure all the value creating relationship, I think that creates the viable organization, which then will survive as long as it is meant to survive. That's my angle to governance. Now, do we have any other questions or comments? Or I know that we've been at this for an hour and a half already. I'm happy to entertain more questions or comments.
Mikko, I'm
Obviously.
conscious that Maria had her hand raised a couple of times before. I don't know if Maria, would you like to pose a question?
Sure.
Yeah.
I mean, I don't want to take anybody's time since you.
No, go ahead. Some of the hands I just don't see, so I just see some of the hands. So if you can navigate, be my eyes for me. So, but please go ahead. Please go ahead.
Thank you so much first for the very, very interesting and thought-provoking presentation. And so my question is, and I do tend to agree with you that board of directors should have fiduciary duty to the organization itself rather than the shareholders. So I personally agree with you on that point. But my question is, well, what do you think about the political reality? And I'm coming here from the US perspective. I think US perspective with huge amount of assets under management, I think close to 130 trillion, right? We know BlackRock is now the world's largest owner. And I think they own like 3 or 4 times more companies that the international rather than US companies. So I guess my question is, we have growing shareholder activism, shareholders are more powerful. We see a number of displaced executives that lose their jobs as a result, and including also board of directors losing their jobs. And we also have, I mean, those index funds, they don't have really the options of exit, right? I mean, we see more common ownership, more universal, the so-called universal owners. So my question to you is, even though I do tend to agree with you that the legal reality should be fiduciary duty to the organization, but how do you think that kind of the law is affected by the political dynamics that the directors face?
Yeah, maybe not necessarily political, but power dynamics. Dynamics. So yes, so yeah, I have always been worried about influential shareholders, especially those who tend to look at corporations simply from an investment point of view. So they don't care what happens in these corporations. They don't care whether their governance is intact. And yeah, and this happens over on this side of the Atlantic as well, that just look at how the CEO of Danone was ousted when he said, I want to consider broader stakeholder interest and not shareholder interest. You know, aggressive activist shareholders put pressure on the board and the CEO was ousted. So there is the kind of the power dynamics reality here that I don't deny. But at the same time, I'd like to try to maybe build a coalition of people to kind of, you know, push back against. But yeah, the US has always been more shareholder centric, I think, compared to many European countries. And, you know, if you look at co-determination laws, for instance, you will find them in many countries in Europe. So there is also a historical aspect to this. But here is a question that, again, Lynn Stout asked this, that how is this shareholder-centric thinking working out for the shareholders? Are they actually benefiting from that or not? And she says that actually investors, shareholders were much better off before this focus on shareholder interest really took foot, which was back in the 60s and 70s. Okay, there are many confounding factors there, but the question that Dr. Stout is asking is, if you are a shareholder, is it really in your best interest to appoint your own agents to the board of directors? Or might you be better off if the board was actually a fiduciary of the entire organization? There is some research on this, and Joe and I cite some of this in the book as well, that shareholders might be compelled to entertain the possibility that having their personal agent on the board may not be the best option. If the aim is to build an organization that is viable and can survive for a long time, then maybe the board focusing on shareholder interest is not the right way to go, even for the shareholders. That is, I think, an idea worth thinking about. that maybe not having my agent on the board, I know it may sound counterintuitive, but we might be better off, all of us, including the shareholders, if the board was indeed independent in the formal sense, in the cognitive sense, in the sense of its judgment. So be disinterested. But I think somebody mentioned in the chat, does this create an agency problem? I don't think it does. I don't think it creates an agency problem. If you have a disinterested judge who exercises oversight, I don't see how that creates an agency problem. I think it's rather something we might want to strive for. Akwasi, go ahead.
Yeah, I was the one who put that comment, I think. Maybe it's possible agency problem is the wrong term, but I find it, and I say this for lack of a better word, I don't mean it in a critical way, but I find it utopian to hope that someone would be a diligent director on the board who has no interest in the firm. And another question I had, which may help to ground this discussion, is you gave the example of Nesti. And I'm very curious, what was their rationale? Is it, for example, a cultural thing in Finland? Is there a legal requirement? What was their rationale to have board members who were completely disinterested in a good way? And how do they choose those people? Is it based on some idea of character, like these people are just good citizens? Because I think if that's the case, that also has implications for the assumptions we make in general about shareholders, whether or not they're good citizens or they're all self-interested, then it becomes a type of person issue, which is a whole other.
Okay, very good. So again, words matter. So let me make a distinction between disinterested and uninterested. I'm not saying uninterested. Board members should not be uninterested, but they should be disinterested in the sense that they have nothing riding on the firm itself. Okay, but that doesn't mean that you don't care. Okay, I am currently in 2 fiduciary roles. I am managing the estate of my late brother, and it's kind of hard to be disinterested, but what I try to do is I try to do everything I can to act in the best interest of the heirs. And of course, this is my brother, this is my family and all that. But at the same time, sometimes I think that maybe it might be better if a lawyer took over and just handled everything. It would be much, much more expensive, but there might be a benefit of having a disinterested party do this. Of course, I would hope that they're not uninterested in what they do. No, they want to do as good a thorough job as possible. I think that this is what we would expect from board members as well. First of all, compensate them for the work that they do, but don't incentivize them. Don't say, you need to do this and this and this and this, and if you do, we'll give you more money. It's to say, you are the fiduciary of this corporation. You will be the chairperson, you will be paid 67,900 euros a year. You will not get equity-based pay. We are not going to be interested in whether you can drive up the share price or not. Your task, that's the task of the management team. The people that we pay millions, those are in charge of making money. You are in charge of making sure that governance is intact, that there's effective oversight. And I don't know, is this utopian? Let me return back to the Attorney General. Is it utopian to expect the Attorney General to be in the service of the United States instead of the president who appointed them? I don't think it's utopian. I think it's, first of all, constitutional. And I think it's something that we should think of as not just as possible, but absolutely essential. So in that sense, I don't think that the idea that the board being a disinterested fiduciary of the entire organization, I don't think it's far-fetched. And this is not the only Finnish company that does this. Now, I don't know. We'd have to go to the shareholders meeting and we'd have to see how people vote and how these people come to be board members. But there is nothing in the law that requires independence. Usually, publicly traded companies have to comply with the governance guidelines of the stock exchange. So if you want to be listed on the New York Stock Exchange, then you have to have the majority of your board members independent of the corporation. Well, here's an interesting thing about many US corporations is they don't just do the majority, they do the vast majority. And many companies do 100%. So it's interesting that the stock market regulations only say majority. Why do corporations decide that we will not only do majority, we'll do vast majority? And in increasing numbers, even among the Fortune 500, the CEO is no longer chairing the board. That's an interesting development. I think it's somewhere around 40%, 45%. Last time I checked, the chairperson also being the CEO. So I don't know. And even if it were utopian, I'd still push toward it as much as I can. I think this idea of the fiduciary relationship, really understanding its essence, is really central. And this is something that I invite my students, my executive students, many of whom serve on the board. I ask them, how do you think of your relationship with the corporation? Who do you think is the recipient of your fiduciary duty? And then we engage in a conversation.